All right, welcome everybody. It is our time of the month for work comp today, as we've been doing for a couple of years now. Dave and I and a colleague, a friend who does the same kind of work we do, we get together and we kind of nerd out on work comp issues of the month. We talk about employers, employees, and everything in between. We want to welcome our buddy out of the Atlanta area, Michael Moebes, Moebes Law. Michael, how are you doing today? And roll tide to you, bud.
Roll tide to y'all. Doing great.
Well, we appreciate you making some time for us today. And I guess I should also welcome David. I mean, I don't know. We'll get around to it. But Dave, how's your day going today?
Doing just great. Yeah, thanks for remembering I'm on. Doing fine. Happy early Thanksgiving to everyone, and roll tide to our friend Michael. Glad you're joining us today.
Is there any truth, David, that because you had the cold day combo at lunch, that you hadn't been very productive until this very moment since lunch? I'm just
Yeah,
saying, that's what I'm hearing. That's what I'm hearing.
Shout out to Dimitri's Barbecue. Had the cold day combo today. Love it. It's a good meal. But I've been working hard for my clients this afternoon.
They're not yet a sponsor, but we're working on it. We're taking offers at any given time to consider. But for now, we must push that aside and hit what we're here for. And what we do every month is we talk about the issues that are currently impacting employers, employees, independent contractors, and whatever is really the part of our practices. And it's usually work comp, it's usually personal injury in nature. And there's so many things here. Well, there's been lots and lots of themes throughout the pandemic for the last almost 2 years. Some of those things are still holding true each month, but we've got a lot of new issues. And we've got about 5 articles or so to go through this month, this episode. But before we do, Michael, I want you to tell us a little bit about your practice. I know we've done some work with you guys in the past, and we've had a good friendship for years. But share with our audience a little bit about yourself and about your practice, if you will, before we get started into the articles.
Sure. Well, I went to University of Alabama at the same time David did, your younger brother, and then I came to Atlanta and I got a job here and worked, and then went back to law school at Georgia State, and then started my career doing workers' comp defense for nearly 6 years at a firm here that now I have cases against all the time. And then April 6, 2009, I started Moebes Law doing workers' comp claimants work, and have enjoyed it a lot more being on this side. And then at the same time, I was in the Air Force Reserves for the past couple of decades. And so I've added some VA disability work in the last few years as well. Smaller part of my practice, but a really rewarding kind of fun one.
Well, what took you so long to see the light? 6 years? 6 years? What's that about?
A lot of self-loathing and trying to save up money. I like the people I worked with. I didn't love sort of the big picture aspect of doing defense work. Like the people at my firm were great. I had a great supervisor and my colleagues were nice and all that. But just after a while, I really wanted to work with the little guy, so to speak, and work with David, not Goliath. So, but it's scary to quit a steady paycheck and do contingency fee work. So especially when you have a family like I did already in 2009. So
it is, but we're glad that you found the light and you're doing the kind of work that we so enjoy doing. And one thing I do want David to mention, all three of us are members of the same national organization. And Dave, if you will, just give a little plug for WILG, and then we'll jump into the articles.
Sure. So WILG is the Workers' Injury Law Advocacy Group. It's a national organization made up of claimants attorneys that represent injured workers, whether it's work comp or Defense-Based Act, longshore, Social Security, disability. Some of the best and brightest lawyers in the country are part of this fantastic organization. And it's where we get to see Mike a couple of times a year at the national conference, Southeastern Conference. Just a really good group to be a part of. And I know that it's made our law practice made us better lawyers by being a part of it. And that's why we continue to talk about it and bring WILG members on like Mike to join us.
It truly, Michael, it really is remarkable when we get together a couple times a year and just the knowledge and the sharing of lawyers from all over the country and the camaraderie. That's three of the aspects I love about this organization.
Yeah, definitely. Yeah, and it's interesting to see what other states are doing well or doing poorly, and because sometimes that can be an indicator of what's coming our way when we see what our neighbors are doing in terms of their workers' comp laws.
It is true. It also makes David and me a little jealous when we see some of the more progressive states and what they're able to accomplish. But we will not jump on that soapbox, at least not for this next little bit, as we do each episode. But we're going to jump into our articles, and our first one is one that's directly impacting our practice. It comes out of the state of Alabama. Brand new set of laws that just came out that the most southern states are following this trend. And the article is Alabama tries to thread that needle on fighting vaccine mandate. Legal experts say that the law is on solid footing. Dave, what are we talking about here, and how's it impact our folks?
Sure. So the Alabama legislature passed a law recently that shields workers who don't want to get the COVID-19 vaccination. So essentially, the federal government said that if a company does business with the U.S. government, or an employer has more than 100 employees, then they can mandate that their employees get the vaccine. Alabama is challenging that in a sense by passing this law, trying to protect employees. And employees, if they have a religious or a medical exemption, they can apply for that to avoid getting the vaccine. Alabama has long challenged federal laws and has a history of losing these court cases, but some experts say that this Alabama law is crafted properly so that it will not be overturned, but time will tell.
And even in our state, as small as we have from a population standpoint, we have many, many, many employers out there that fit this criteria with 100 or more employees, whether it's in the insurance industry, the manufacturing industry, or it could be Amazon, which now has many distribution centers in our state. Michael, I'm sure that Georgia is following this same trend, and with even a larger population in the state of Georgia. Have you seen this come across your desk or heard of these issues pop up just yet? It's brand new in Alabama. I suspect it's a little bit older or more been in place maybe in Georgia longer.
I have not. It's funny. I have a friend in Chicago who has asked me about a lot of this stuff because, of course, they're more progressive and more ahead of these types of issues than we are in the South. But he grew up here, and maybe I'm his only lawyer friend. But so he's asked what we're doing here. And as we talked a little bit before we went on the air, Governor Kemp has, been in national media sort of poo-pooing having to wear masks or having any restrictions at all through the last year and a half. But I'm actually not sure if we have a law similar to this in place, but I'd be surprised if we don't, to be honest with you. But, as a small business owner, it doesn't affect me. Most of the law firms even I have cases against don't have 100 people working there. Some of them do, but you're right. I mean, we certainly have huge employers like, IBM and Cox Communication and, BMW, Mercedes is North American headquarters right by where I live. Those obviously have many, many employees.
Well, let me throw a hypothetical to you both, and I want you to come from your perspective, from your respective states. Let's say it's an Amazon distribution hourly employee. Let's assume for this argument that there's well more than 100, that Amazon is one of these subjected companies, and they have required their employees to have vaccinations. But we now have somebody in this example who works back in the warehouse, and pick whether it's religious reasons or medical reasons, they have an exemption they're trying to put forth. How do you advise your respective clients? How are you going to deal with this when the employer says, it doesn't matter to me what this is. I don't care about that law. I'm a national company. I'm taking my orders from headquarters, which is out of state. So the employer says to your clients, get on board or you're gone. What are you doing here, Dave? How are you dealing with your client?
Well, but I mean, before the passage of this law in Alabama, I was telling people that would call me, said, yes, your employer can require you to get the vaccine unless you have a medical or religious exemption. And if you don't get the vaccine and don't have a valid exemption, then your employment can be terminated. Yeah. Okay. Now we have this law in place in Alabama. So my analysis is a little bit different. And I don't think the law goes into effect until I think January 4th.
Yeah.
So
it's a couple months.
Some time there for it's going to, got to consider.
I do know in Alabama, Michael, before we get to you, there's an appeal process. And when you appeal, the employer still holds, we're not going to accept your exemption. You then have to file a lawsuit in circuit court. Now, the what I have read about this law, it doesn't give much guidance after that. So it's going to be whoever's first up is going to be the test case for our state. Michael, I don't know if your laws or how would you advise somebody who's calling you and has this same scenario, but you're in the state of Georgia?
I would say pick the most subjective caveat you can pick and say that's your problem with it. In essence, if someone who just really doesn't want to get the vaccine, I mean, I know a lot of people I know have recovered from the illness in the past, say 3 months, 6 months, including me. And so wanted to wait at least until that window was closed, like 6 months out before doing it. But if the religious exemption is the most subjective one that's there, and someone's calling me saying like, hey, I don't want to lose my job, I also don't want to get this shot right now, I would say assert that. That's subjective. But I did see, I pulled up on my other screen here that our governor filed a lawsuit against the federal mandate to try and stop it, in essence, on November 7th. So just a week or two ago.
Yeah, and I think our attorney general is doing the same thing.
Yeah. The
That's
governor and
right.
our attorney general filed lawsuit on Friday, the 7th.
So for this one, let's put a pause in it because it's going to be, we'll come back to this next year. I am sure of that. This issue is not going away like many others related to the pandemic. So we'll put a cork in it in that one for now, but let's move on to the next one. This one is your home state. And it's really interesting when you try to describe to someone who's never dealt with the idiopathic defense. When you have somebody across the table who has been injured and we're talking about defenses, you immediately, at least for me, I immediately have to explain, I'm not calling you an idiot. That's just what this term is called. And now out of Georgia, it says idiopathic defense to workers' comp claims is still viable in Georgia, according to a recent ruling. Michael, I know as long as you've been practicing on both sides of the table here, you've had to have dealt with idiopathic defense at least at least sometimes. So talk to us a little bit about your experience and what this court ruling is all about.
Sure. Well, it's funny. I said April 6th of 2009 is when I started my own firm. So April 6th of 2009 was my last, the third. Anyway, Friday to Monday. But one of the last cases I had, this was our defense. And I felt horrible for this lady who was a nurse and was like running because someone hit the patient button, for an emergency down a hall, very similar to this teacher in the Stokes case that is in the article that we're discussing today. She fell and she was an overweight lady and just landed so awkwardly. She ended up having to have her leg amputated at the knee. And of course, I worked for Liberty Mutual then, and I was defending this case, and I was, heartbroken over. I went there and did a site inspection. I found the tile had this little bitty bump in it, and I thought, well, if the claims attorney comes here and does a site inspection, he'll see that, and he can argue that caused the fall. Because this lady in the Stoker case versus Walker County Board of Education, it seems that it was truly idiopathic in that she didn't fall on anything. She was kind of going down the hall at maybe an increased pace. And I did have a couple cases like that as a defense lawyer where a cop was walking in a hurry and just fell and messed up his knee, or this lady in this nursing or medical facility, same deal. And I actually tried that case with the cop and won where, it was idiopathic when I was still a defense lawyer. The other one, that case went to someone else because I changed sides of the aisle, but I followed up with the claimant's attorney because I said like, hey, I didn't want to tell him, I couldn't tell him, go look at the facility and you'll figure out how to win this case. But I was like, I followed up to find out how it went. And he waited a while until actually a judge retired and he got a better judge in his mind and then tried the case and actually was able to win and even at the next appellate level. So I'm glad, because this poor lady, like I said, lost part of her leg. But in the case that's in the article, this teacher seemed very similar to my lady at the medical facility, where just walking down the hall in a hurry, but they said it is idiopathic.
And Michael, what is idiopathic in its general terms? What does that mean?
Oh, yeah, just that, to have an injury that's workers' comp, it has to arise out of employment and in the course of employment. So you're definitely in the course of your employment during your business hours when you're walking down a hall, but it may not arise out of your employment if your injury wasn't caused by, a task specific to your employment. So idiopathic means it can happen anywhere.
And to me, it also, Dave, see if this rings true with your experience. If you have a potential client trying to describe how they got hurt, and they say, I really don't know how I got hurt, or I don't have an explanation, I've gone over it in my head, I've looked, to me, that's an unexplained event. And if you're in front of an Alabama judge with that as your argument, Dave, what happens?
You're not going to win that case. If you can't explain why you fell, or you can't explain what caused your knee to buckle, then that's idiopathic. You have to be able to explain and relate what the job, or how it happened, is related to the job duties.
Yeah. I remember losing a case on summary judgment when I was a young lawyer, when my client, who was a nurse, slipped and fell or slid through water that leaked from a water machine. It wasn't a water fountain. It was where you can get ice, and it was near a fridge, but something froze over or leaked, and that's where she slid. And even when she was asked under her deposition, were your pants wet, or those kind of things, she just could not explain. She couldn't, in her mind, connect why and how she ended up sliding. So the judge says, if you can't tell me how this happened, how can I find benefits for you? And again, it was a bad knee injury, but it is what it is. And it's an idiopathic defense that still creeps up in many, many cases that we evaluate.
Yeah, I was going to say, one thing that can help is, I had one case where a prison guard passed out. It was really hot. It was in Macon, Georgia in the summer. And I was able to get, comp benefits for him because he passed out and his face hit a chain link, and there was a mark on the top of his nose like I have from wearing glasses, and y'all probably do too at the end of the day. And then he came down and injured himself. But that's the positional risk doctrine in Georgia helps you if you have an injury that may have otherwise been idiopathic, but then you hit something that's only there because of your job, right? A desk, like in my office, I have a desk, as y'all do too, credenza, or in this case, a chain link because he was in the prison yard. Mm-hmm. And so that can help you. But one thing I've seen not work is being in a hurry, like that police officer and like this lady in this case, like walking fast. I guess they figured like lots of people walk fast. That's not related to work. So,
yeah.
Unless you're a bullfighter or something like that, where fast is required. But guys, I want to welcome you. If you're tuned in just now, or you've been watching or watching on replay, this is our monthly Work Comp Today. It's our live YouTube show where we talk about all the employer, employee, and independent contractor issues that come up in the preceding month that impact our practice, impact what we do. We always have a buddy of ours, a colleague. And this month we've got out of Atlanta, Michael Moebes with Moebes Law. Michael's been a buddy of ours for a while. He and Dave were at undergrad at Bama together. And we're just running through articles that impact people who may end up calling us or may need some of our services or advice from time to time when they get injured on the job or related. All right, guys, we're going to move to number 3. This is out of the state of Washington. Hundreds of COVID-19 workers' comp claims in logjam at Washington Labor and Industries. And I'm not as concerned about what's going on in the state of Washington as I am about what's going on in our respective states. Dave, is there a logjam that you've been aware of in our state with COVID-19 related claims?
No, there's not, because they all get denied.
Right.
It's no logjam.
Yeah.
There's no presumption that if you got COVID at work, that it's going to be covered under work comp. Many states passed what's called presumption laws that said if you're a healthcare worker, a first responder, police officer in the medical profession, that if you got COVID, it's presumed that you got it at work. And so therefore you'd be covered by your employer's workers' compensation benefits program.
Yeah.
But we don't have that in Alabama. So therefore these claims are quickly denied by work comp.
You know, in the article, it does say in the state of Washington, they've got over 300 claims that have just been lingering without a decision for 6 months or longer. We have a different system than they do in Washington, or really in every state. We are a litigation-based system. We're a no-fault set of laws, comes out of Minnesota, that we followed and been recodified and updated. And I laughingly say updated because it's been since '92 since they were updated. But we don't have that logjam like Dave said. And it may be, some of it may be the nature of the industry that is impacted by the claims in Washington. But Michael, what about your experience? We certainly have looked at many, many claims and fielded many, many phone calls, but have only taken on very, very few cases. Is there a logjam of you're aware of in the work comp industry in Georgia?
I don't think so. And similar to what David said, my state senator, Jen Jordan, at the state legislature tried to bring forward, and we're a very red state in the state legislature, and she's a Democrat. But anyway, it was defeated. I don't even think it got up for a vote, but to let first responders get that presumption. And like y'all, I'm sure I've had lots of people call me. Some of the cases are sad, but physicians who miss 2 or 3 weeks of work, I'm like, well, we have a 7-day wait period and you have health insurance. Yeah. So did you have some vacation time while you're out sick or sick time? Yeah. I'm like, do you want to tick off your employer by filing a comp claim when you're talking about 2 weeks of benefits at $675 a week and your doc making, $300,000 a year? Probably no. Okay. So I've had really, unless someone dies or, has long COVID where they're out of work a long, long time, they're a high wage earner and no health insurance. Unfortunately, financially, it's probably not worth bringing the claim. But second, they're going to be denied, and you're going to have to, appeal it up. Because the people I know who tried to bring claims, no one has tried a case, but no one has had any settlement offers either. And I have a couple where they had a physical injury and COVID, and so it was sort of a part of the case, but not any that I've accepted that were exclusively COVID cases.
Yeah. And that's been largely our experience. Dave, are you aware of any trials, any verdicts from judges?
No, I have not heard any, just specifically COVID. No.
Yeah.
Well, and it's not going away. We're going to have these still to continue because it's, as the pandemic close to entering its second year, hopefully things will settle down, but we don't know the long-term impact. And I don't know if this is a good analogy, but they're just learning the long-term impact from exposures from 9/11. They're still dealing with that. They will be for decades. I don't know if this will run the similar course. It's completely different in nature, but it's just, I guess in my world, or my thought is, it impacts such a very large part of our society and just has different outcomes, if you will. But anyway, let's move on to number 4. And good old Amazon makes its way into our show almost every month. While we love what Amazon does for us as consumers, unfortunately, we have way too many Amazon claims currently as clients. I don't know, Michael, if that's part of your practice, but we have distribution centers 2 miles to our east, 10 miles to our west, and that one is just opening. The other one has been going for a while. And we seem to hear from Amazon folks monthly. I don't know about your practice, but do you have an Amazon practice as well?
Yeah, I signed one up today. So I've gotten to know the Sedgwick CMS adjusters pretty well because that's who does their comp, of course.
Oh, yeah. Oh, yeah. Well, Dave, let's see. Injured Amazon worker in Florida denied workers' compensation and threatened with termination. And frankly, while we're talking about Amazon, you could substitute the state of Florida for just about any other state. This seems to be a trend with Amazon. But what was your take on this one?
Yeah. So, I mean, this article is just paints a long story over several months of this one particular Amazon employee in Florida and her attempts just to get basic medical care related to what she considered to be pain and symptoms and injuries stemming from her job. And she just talks about a brutal system that there at Amazon that's done to delay treatment, to make her feel as if she's done something wrong, and just to do anything they can to really force her out in a sense and make her feel bad for getting hurt. And it's a sad situation, and it's just one that should not be tolerated.
Michael, if this is going on in Georgia, does Georgia have anti-retaliation laws as part of the work comp system?
No, I think y'all have a tort right for wrongful termination after workplace injury. We do not. And I had a conversation with a potential client today about that, where they're threatening to fire him. He's like, well, my union says they can't. And I'm like, well, your union may have a deal independent of the law, but in Georgia, you can be, in essence. There's no like wrongful termination tort. It's a employee at will state. I call it a right to fire state, but
Yeah. You know, it's really, and I'm going to let David comment on this. Our separate action falls under the work comp laws, but it is a separate tort. And Dave, how does it treated? Because it's a whole different animal, if you will, compared to work comp.
Sure. So it's called retaliatory discharge. And if the employer fires the employee for making a work comp claim, then that violates the law. Now, the key is that the sole reason, the only reason that the employer fired the employee was for making a work comp claim makes it illegal. So if the employer has any other reason for firing the employee, then the employee won't be able to then the employee won't be able to prove retaliatory discharge.
And they usually just make something up. It can be so simple that even though we are an at-will employee state as well, or like you said, it really is pretty remarkable how easy it is for employers to just let them go. It usually takes, I guess, circumstantial evidence, but we do have the right to a jury trial as opposed to a judge decision in work comp, and all different types of damages can be considered as well if you get to that part, that in comparison to work comp, it's so very limited in our state. But going back to Amazon, they're so big, so many people want these jobs. I'm sure that it is a precious job to keep. I'm sure it's very hard work, and a lot of people do get hurt, but Amazon is such a large beast that I'm sure they have, for every one position, many, many people who want that job who are unemployed. And so it's tough. It's a tough road for this person in Florida, but not surprising at all. Anything else about that one, or you want to move on to what I think can be some of the most difficult but very fact-specific type of cases we look at almost every week? This one is coming out of what state? Where? In Ohio.
Ohio.
Court says employee deserves workers' comp, and I love how they spelled it wrong, for workplace parking lot injury. Now, Dave, we'll start with you. Let's talk a little bit about the coming and going aspects and how these cases are so very fact-specific to determine if there's compensability in Alabama.
Yeah, so earlier Mike talked about how you get work comp benefits. You have to be injured in the line and scope of your employment in the course of your duties, right? You're performing your job duties, you're at work. Well, what if you're on your way to work or you're leaving work? That's called the coming and going rule. So usually if you're coming to work or leaving work, that's not going to be covered under the Work Comp Act. And so therefore you won't get work comp benefits. Now, what if you're in the company parking lot, right? You have a designated parking deck or a parking lot, and that's where you're supposed to park. So even if you're not clocked in, right, even if you haven't started your work day, if your employer requires you to park in a certain lot or area and you get hurt in that parking lot, that very well may be a compensable workers' compensation act where you can get benefits for getting injured, even if you're not clocked in.
Mike, does Georgia have similar analysis of these types of facts?
We do, yeah. We have reasonable ingress and egress, that can come into play in these cases. And then the parking lot exception is, my understanding of the law is if it's a parking lot that's sort of exclusively owned or managed by the employer, it can be included. And one day we had snow and ice, and I had a lady who was made to come into work. When she called in and said, I don't think I can get to work safely. It was a snow day. Kids were out of school. He said, come anyway. She did, and was walking on the sidewalk, and it was icy, but it was a building with a parking lot exclusively managed, and she was able to get benefits. She had to have 3 knee surgeries because her fall was so bad.
Wow.
And I have a lady I signed up, recently, who I'm representing now, where she was in her car, like just kind of messing around on her phone, like a lot of us do on a break while having her lunch. But she traveled there. She's a traveling employee. So that's a little different. Because I said, I know your case was denied because of this parking lot rule. Your parking lot wasn't managed by your employer. You were there on assignment in essence, or because you're on a designated break. It was a paid break. But for us, and I may be going off the rails a bit, but if you're a traveling employee, like a traveling salesperson, or, a cop who basically does his or her job at a different location, not so much at the station, but where they're, helping people, arresting people or whatever, then, that is their workplace. And so I'm like, that's what we're going to argue, is that when you were in that parking lot, you were assigned there. She was out of town. She was assigned to go out of town, put up in a hotel and all that stuff on the company dime.
Yeah. Let me ask you this scenario, throw this to you. I'm going to give you 2 different ones. The employer does not have a designated parking deck or parking lot. They don't provide an allowance for parking. You park wherever you want to park. And let's say your client parks across the street. They're in the crosswalk coming to work. They step in a hole, break their foot. They're not on the clock per se because their salary. They hadn't clocked in, is what I mean. Dave, is that going to be a compensable work comp case in Alabama?
That's a harder case if they're not parking in a company designated parking spot or parking lot. There's probably a premises liability case there if they stepped in a hole and broke their ankle.
Yeah.
I know there is an Alabama case where someone was run over and killed in a crosswalk. They had parked in a company designated parking lot across the street from the business, then had to walk in a public street, in the crosswalk to get to the facility, the place of employment, and they were killed in the crosswalk. And that was considered a compensable, a covered work comp claim for death benefits because they had to park in that parking lot off premises and then walk to the building.
And for that matter, wouldn't they also have another third-party claim from getting run over?
That's right. Yeah, against the person that was driving the vehicle that killed them.
So they may have those 2 claims, but not a work comp claim in this scenario. Yeah.
No, if they were parked in a designated parking lot, they were required to park in by their employer, then it's a work comp claim.
Okay, I'm sorry.
Yeah.
I'm sorry. All right, Michael, what about if it's in Georgia? And let's do a little bit different scenario. Let's say that you're in a ride share deal and then you go and park at a MARTA stop and you are getting on the train, and this is how you get, and the MARTA train takes you to your place of employment, and you get hurt coming in and off of the train. But that's how, you can't park at your building. This is how you have to come to work, but you get hurt because you're on the train. You misstep or something.
Probably not. I mean, I think that would be a really difficult argument to make. If the damages were high, I'd probably take the case and try. But I think stepping off the MARTA train is far enough removed. And just, thinking practically here in Atlanta, like our MARTA goes through, downtown and midtown, but most of the offices are pretty good distance from the actual train.
Yeah.
And, maybe unless you're working like at the airport where it stops in the airport and you're like right there, like maybe that would certainly be a stronger argument. You're right there in that proximity. And especially if your employer pays your MARTA cards and you are told you are expected to take the train to work from a designated parking area, then it's close to what David was just describing in his scenario.
Yeah, and that's why these coming and going type of what we call these types of cases are so very fact specific. And you're right. If there's enough damage there, personal injury and whatnot, to the potential client, I think it's definitely worth looking at the next level to see if there's a claim to pursue. Not that the other ones aren't, but it is a factual analysis for these types of cases. Well, guys, that's the end of our articles for this month. And what we usually do in the second part, which doesn't take as long, is we want to do a little comparison to Alabama laws and policies, procedures that impact work comp with our guests' home state, with Georgia. So I've got a couple of topics I want to throw out. We'll start with you, Michael. Let's talk about a scenario that you have resolved a case for your client, and as part of the resolution, whether it is a negotiated settlement, or you go through the administrative process and get a court order or a administrative order, whatever it may be. But open medicals for life is what I'll call it. Meaning, well, I'm going to ask you in Georgia, what does that mean? And Dave, the same question for you.
Sure.
Open medicals for life.
Well, I'm chuckling because we used to have open medicals for life unless you settled the case and closed it, and that changed effective July 1, 2013. So I have a few like legacy cases where they're still getting medical indefinitely, but if you're hurt after that date, basically your medical goes for 400 weeks from date of injury, just like your disability checks will, unless you're deemed catastrophically injured, meaning you're never going to work.
We'll come back to that. We'll come back to catastrophic in a few minutes.
Yeah.
But so open medicals for life, unless it's catastrophic, will stop at 400 weeks.
Correct. And a lot of clients, they want to, like, I talked to someone today, wanted to settle his case. He's like, well, I need future medicals. I'm like, the insurance company wants to write you one check and be done with you, close their file. So very, very rarely do I see a case settle with any open medical. And if it does, it's a very limited time period and a limited procedure, like physical therapy for 3 months, and that's it. Or one injection and PT for 2 months, but no surgery, no carte blanche open meds.
And Michael,
Dave,
hang on, Michael, does the 400 weeks start at the time of the injury or at the time of the settlement?
Yeah, the date of injury.
Date of injury.
wow.
Yeah.
So we're talking, what is that, 400? Was it 7 years, 7+ years?
Yeah, roughly 7.5 years.
Wow. Now, Dave, when we say open medicals for life, the typical client, until we have to really educate them, they may have one concept of what that means versus the reality of how it actually works in our practice. So kind of share a little bit of the actual reality of what open medicals.
Sure. So if we settle the claim or settle the case with open medical benefits for life, that literally means open medical benefits for their lifetime. But there are some limitations with that. And what that means is they have to treat with the authorized treating work comp doctor, and they can't wait 5 years between medical appointments, because work comp can come back and say, how do we know that your problem today is any way related to what happened 10 years ago, 5 years ago, whatever. So, but it does cover lifetime medical care through the authorized treating physician. They can't just go out and find any doctor, of course. But as they get older, as we get further away from the original date of injury, it gets harder for those doctors to link back and say your current problems are related to the work comp claim. So therefore, it's best for the clients to go see that work comp doctor on a yearly basis, just to check in and keep tabs on them.
Yeah, that's a big fight. Medical costs only are going up. And on a related note, how often, Michael and David, do you get phone calls from either your client, well, I guess now former client, because you've resolved the case, or you get a call from the insurance attorney saying, hey, we want to explore closing medicals on this one. It's been years. How often does that come up in your practice, Michael?
Not that often, other than they'll say, the language is more like, we need to settle this case, but which means we want to turn off the spigot of medical. So because once the case is settled, their medical is done. And I was going to throw in a minute ago, but certainly the Affordable Care Act or Obamacare helps in that regard, because especially this time of year, because open enrollment, so people are scared to resolve their case without open meds. I'm like, well, you can go get health insurance and pre-existing is not excluded, and then keep treating.
Yeah, that's a good point.
Dave, how often do you get that call?
It's pretty frequent in Alabama because just like in Georgia, I mean, insurance companies want a closed file, right? An open file costs them money. It's significant cost to them every year. They want a closed file. And, a lot of our clients end up closing their medical benefits. Now, certain clients just cannot close medical benefits, right? They're paralyzed. They're in pain management every 90 days. They've got ongoing definite medical needs. You're not going to close medicals in those cases unless there's a Medicare set aside put in place. And that's a whole other thing. But we get calls frequently from insurance companies wanting to close files.
Here's the most notable one I got last year. Michael, there was an Alabama case, injury in South Alabama, when David was 8 years old, that our father handled. Medicals had been open for 37 years on a claim.
Wow.
The client was finally fed up with it. We ended up closing the medicals at his request and got him some good money. But that case was 37 years old. All right, we got two more before we wrap up for this month. Let's talk about horseplay. Can horseplay in the workplace lead to any type of compensable claim? And here's some horseplay. Let's say you got two guys, just guys being guys, and they're trading punches because they wanted to see who punched harder, or they're messing around by throwing things at each other, or there's a million different examples that we've dealt with. Can horseplay in any context, David, in your experience, lead to a compensable claim?
I mean, generally, if the employee is involved in horseplay, then that is a defense to a work comp claim most of the time. Now, again, we talked about situations like these are very fact specific. You've got to explore the facts. Yeah. We were successful in a case not too long ago where one of the coworkers, my client's coworker, was involved in horseplay. He was trying to throw water on him. Okay. My client was doing nothing wrong other than trying to avoid getting soaked with the water and ended up injuring his ankle and leading to multiple surgeries. And that was a compensable claim. My client was just trying to get away. He wasn't involved in the horseplay. He was the non-horseplay guy. So.
Michael, what about, and I hate to use this analogy, what about snake play? What about picking up a rattlesnake in South Alabama to show your coworkers that you're a man? Could that lead to a compensable claim? Obviously, that's a case in Alabama.
Is it?
Yes.
Oh, wow. There's a rattlesnake roundup in Claxton, Georgia, and I pass it every time I'm driving to St. Simon's Island. And I'm like, I don't know who does that, and I don't want to.
But wait, what if that's your job? What if you're hired by the city to be one of the rattlesnake wranglers?
Then I would say that's covered.
Can you think of any similar examples like Dave just gave, where you're the victim of horseplay? You didn't instigate it, but it still led to compensability.
Not where you're sort of directly getting over a horseplay defense like that. I mean, I've certainly seen a fight break out, or someone being like really careless, and of course comp is no fault. I've even seen someone be really careless and have a positive drug screen, but I was able to argue, well, this injury would have happened regardless.
Right.
Comp been positive for marijuana or something, because the other person was so negligent in their actions. So it's just a rebuttable presumption on that. Yeah. Yeah. But I can't think of a case that I've had that horseplay was the only defense and we were able to sort of get beyond it. But, where both parties are kind of screwing around, and, and your client is equally at blame, so to speak.
I think if you're the instigator and you get hurt, I don't think you stand a chance. I don't think any state would allow for that. All right, guys, let's move on to our last topic. And you had partially brought it up. It's called catastrophic injury in Georgia and Alabama. We commonly refer to it as a permanent total. What does catastrophic mean by way of the way the laws treat it? What type of injuries are we talking about, Michael? What are we talking about from an abilities standpoint, according to your administration? What does that mean?
Yeah, as a practical matter, it's funny. Sometimes I'll have clients be like, well, I should be catastrophic. We should file for that right now. And I'm like, well, you were injured 2 months ago, because it doesn't mean more benefit in the short run. It just means instead of 400 weeks medical and weekly checks ending, they go on for life. So if I'm evaluating a case for settlement, I'm looking at their life expectancy, not how far are we from 400 weeks. Yeah. and there are certain issues like, third-degree burns on your a certain percentage of your body, your face and hands having second-degree burns or higher, et cetera, that get you automatic, catastrophic, or permanent benefits. But the sort of catch-all provision is a lot more subjective, and that's where we usually find ourselves, arguing with, someone who's had 3 failed back surgeries. Are they catastrophic? They're not paralyzed or blind or badly burned, one of those, or brain damaged, but they, as a practical matter, they're never going to work again. So that's where you have, litigation a lot of times.
Well, Dave, what does PTD, permanent total disability, mean in Alabama?
Inability to go back to their old job or find a similar job, and inability to find or be paid wages similar in remuneration to what they were making when they got hurt. Okay. So they don't have to necessarily, Michael, be paralyzed or blind or burned all over their body. And they might not have those severe of injuries in Alabama, but they can't go back to an old job, similar job, and they can't find a job making similar wages. That is the definition of permanent total disability in Alabama. And if they're found to be permanently totally disabled by an Alabama Circuit Court judge, then they're going to be paid. They're going to be paid 2/3 of their average weekly wage, also known as their comp rate, and they'll get paid that for their lifetime so long as they're disabled.
And that can also be revisited by the insurance company when they suspect that there's not disability or a permanent disability anymore.
That's right.
We have to caution our clients that the insurance companies can do surveillance on them at any time. And it usually is part of the equation that we have to deal with to make sure that they are mindful of not being fraudulent in any way. Well, guys, I think we've exhausted our talk for this month. Anything else that before we part ways that of significance? But I want to remind or remember that, Michael, if folks have a Georgia-based claim and want to talk to you to see if they have a case or to get some advice from you, how can people reach out to you? What's some contact information?
Oh, sure. My website is molaw.com, and I got tired of trying to spell Moebes over the telephone, so I made my URL MOE as in Mike Oscar Echo law.com. I'm at Moebes on Twitter, or Atlanta.lawyer on Instagram, and Facebook.com/Atlanta Workers Comp. But basically, and I'll take cases all over Georgia, even though I'm based in Atlanta. I do a lot in Macon, Savannah, North Georgia, South Georgia. So I don't mind getting on a plane or driving.
We're going to put in the comments section the link to your website, so folks who are watching this on YouTube can just click the link and get to you.
Right.
Dave, any big Thanksgiving plans? I know that your food is always on your mind. I know that we're less than a week away from your big meal. Well, that's every day, but for this particular meal. Yeah. And is it true you'll be wearing stretchy pants on Thursday?
Absolutely. I'm going to go for a run Thanksgiving morning. We're going to go to a shelter and help serve as well. And we're going to eat big. So looking forward to that. And just a quick message to injured workers. If you've been injured at work, you have questions, pick up the phone, call a lawyer. There won't be any charge for a consultation. And don't do this on your own. Rely on a lawyer, get some free advice. And if you've been really hurt, you probably need to hire a lawyer.
I heard one of our lawyer buddies recently say, don't let the internet be a substitute for hiring a lawyer. It's too easy to just start Googling things. And the worst thing that we hear is, well, I've been doing some research. Well, where'd you see the research? Well, it's from the state of Kansas, and here's how they treat it. Do you live in Kansas? Is this a Kansas case? If so, we'll send you to a buddy of ours in Kansas. And I know you deal with that as well, because everybody has a smartphone. Everybody wants to start research, just like you do for your own medical care. It's a dangerous thing, that internet. What do you tell folks who maybe are on the fence? They don't know lawyers. They're afraid to call a lawyer because they're going to start charging me. How do you tell folks who are just calling you to kind of put them at ease a little bit about the process?
Well, I tell them, first of all, like I'm the last person to get paid. So my goal is number one, to get you the best medical care we can get you within the confines of the compact. Number two, get you as much money as we can possibly get you within the confines of the workers' compact. And then after all that happens, I get paid a contingency fee amount. But, and I just tell them like, look, the employer and the insurance company have armies of experienced adjusters and lawyers whom they use, and nurse case managers, and all these people are trying to get your case closed as quickly and cheaply as possible.
Yeah.
You need someone to guide you through this process and be your advocate. So, and I enjoy doing it. And I'm like, look, you have nothing to lose from having me help you. I want you to get the best medical you can get and get the benefits you're supposed to get. So,
well, that's certainly sound advice. And Michael, thank you for sharing some time with us today and giving us your viewpoint, from a Georgia standpoint. So thank you for spending some time with us and talking with us.
Yeah, it's been
Dave and Michael, I don't know why I do this, but I always give David the last word. I have to. I guess mom makes us, but whatever it is. Dave, send us off today.
Michael, thanks for joining us. Good to see you. And I'll end with Roll Tide. And as long as Alabama beats Arkansas Saturday, the Iron Bowl doesn't matter.
Except in our hearts.
That's right. That's right. Happy Thanksgiving, everybody. Thanks for tuning in. And as always, catching up with us each month. Michael's contact information is in the show notes, so you can just click on his link to his website. Y'all be well.